Hi everyone, this is the second of those 3 videos that I promised. This video will deal with the material that was to be part of our March 24th class. The focus of this lecture will be SABS dispute resolution. As part of the March 24th class, I was also going to have a guest lecturer. It was Carl Deisha who was going to speak on the defense perspective. Unfortunately, given everything that's happening right now, I had to cancel that guest lecture. So this material will focus solely on the SABS dispute resolution procedure. So what we are dealing with here is the situation where the SABS insurer denies payment of a benefit. So for example, refuses to pay the individual's income replacement benefit, or refuses to deem the individual catastrophic, or refuses to pay for the individual's physiotherapy or massage therapy or even their psychological counseling. What recourse does the individual have in those circumstances? And because the insurance company holds the purse strings and is the one that is primarily making the decisions here, these procedures primarily apply to the insured person. It is typically, and more often than not, the insured person who is seeking to overturn the insurer's decision. There are, though, and you should be aware, some cases where the insurance company advances the claim against the insured person to, for example, recover arrears in payments that were paid in error. Now, over the years, the dispute resolution system has changed dramatically. In the past, claimants had access to mediation, arbitration, or court proceedings, and they could make the decision as to which they chose to use. Now, disputes are solely handled by the License Appeal Tribunal. We are going to first go through the general claims handling procedures, and then we will look at what happens when the insurance company refuses to pay a benefit. To understand the dispute resolution process, you need to have a basic understanding of the claim process. What happens when an individual seeks payment of a benefit? And you can see the chart that I have up on the screen. It starts with a notice to the insurer after the individual has been involved in an accident. Once the insurance company receives that notice, there are 3 forms that typically need to be completed. That is the OCF 1, 2, and 3. The 1 is the application for accident benefits. This is the document that describes, the individual's personal circumstances, whether they were working at the time of the accident, if they were responsible for caring for another individual, where they live, what types of insurance coverage they have, and so on and so forth. The OCF2 is completed typically by the employer, and the employer would outline the income that the individual earned in the 4 weeks before the collision, as well as the 52 weeks before the collision. This is the document that is used to determine the quantum of the individual's income replacement benefit. The 3rd form is the disability certificate. This document is completed by a health practitioner. So typically the individual's medical doctor or their physiotherapist, nurse practitioner, optometrist, that sort of thing. In this form, the doctor would be outlining the injuries that the individual sustained, as well as how long they expect those injuries to continue for. The disability certificate is also the form that triggers the injury classification. This is what determines whether the individual will fall within the MIG, or the non-catastrophic category, or the catastrophic category. It's important that the health practitioner completing the form uses the proper language and understands the impact of the form. If they complete it improperly, the individual, for example, may not qualify for income replacement benefits. One of the phrases on the form, for example, which deals with the non-earner, is, does the applicant suffer a complete inability to carry on a normal life? If the physician checks no, which a lot of physicians misunderstand what that test means, the individual then would not be able to access the non-earner benefit. So that form and what the physician does with it is extremely important. From time to time, the insurance company will also request updated disability certificates. So these forms are not just completed at the front end of a claim. The insurer has the right to ask for them, but the insurer is not allowed to ask for them more often than is reasonably necessary. And again, those forms continue to be used to determine the ongoing entitlement to various benefits. Once all three of those forms have been submitted, the claim will commence. The insurer will review the forms, the insurer will determine what type of benefits the individual is entitled to, classify him or her into the appropriate category for med rehab benefits, and ultimately respond to the individual. The insurer has 30 days to respond to the application forms and advise of the entitlement to benefits. Now, during the lifetime of a claim for accident benefits and after the initial application is filed, several forms will pass back and forth between the insurance company and the insured person. So if you look at the left-hand side of the slide, the items, the arrows in gray, these are the forms that are most commonly submitted to the insurance company by the insured person. To go through some of these forms, there's the OCF 19 application for determination of catastrophic impairment. That is the form that is required to be completed and submitted in order to meet the catastrophic designation. There's also, you can see the OCF 18 treatment and assessment plan. Whenever the individual wishes to access treatment, whether it be psychological counseling, massage therapy, physiotherapy, the individual must have their provider submit the OCF 18 form. The Form 1 assessment of attendant care needs, and we've talked about that previously, that is needed to access the attendant care benefit, and that too would be submitted typically by an occupational therapist and determines the level of care that the individual requires. The OCF 6 expense claim form is the form that the individual will complete for recovery of payment for any out-of-pocket expenses. So, if the individual has to pay for their prescription medication up front, they would list it on the form and be reimbursed by the insurance company, as an example. On the right-hand side of the screen are the forms that are typically submitted by the insurance company to the insured person. The first one is the OCF 10 election form, and we've talked about this as well. This is the form that the insured person must complete to elect one of the income replacement benefit, non-earner benefit, or caregiver benefits. The insured person, as I previously said, must make this election. The insurer cannot make that determination for him or her. The other form is the Section 44 examinations by the insurance company. This is used when the insurer says, I don't know if you should get the benefit requested, and I want a doctor or another health professional to decide. And so the insurance company would then send the individual to their own assessors to do, a medical examination or a psychological evaluation, whatever the type of assessment is, and determine whether or not the benefit requested is reasonable and necessary, and or the individual meets the requisite disability test to access the benefit. The assessment can be both done in person and also as a paper review, where the insured person does not actually attend the assessment. This Section 35 deals with that OCF 10 election. I'm not going to go into too much detail with it. We did talk about it previously. The insurance company is obligated to, within 10 business days after receiving the application, give notice to the applicant advising that he or she must make the election within 30 days. And again, that election must be made by the insured person. The insurer cannot make it for him or her. With respect to the election, the only time that the election can be changed is if the applicant or the insured person is later deemed to have sustained a catastrophic impairment. In that case, the applicant can re-elect the caregiver benefit because, as you know, that caregiver benefit is only available if you have been deemed catastrophic. So there is an opportunity to change the election to the caregiver benefit once deemed catastrophic. In all other circumstances, the election is final and cannot subsequently be changed. With respect to Section 44 examinations, these are the examinations booked by the insurance company when they say, we want you to see a medical doctor, for example, to determine whether or not you qualify for the benefit. The insured does have the right to require the insured person to be examined by one or more persons of their choosing. This can include, medical doctors, rehab specialists, vocational specialists, and so on. If you look, on the slide right before the highlighted portion in bold and underlined, it does indicate that these assessments cannot be made more often than is reasonably necessary. So the insurance company cannot send an insured person to assessments repeatedly. There is a limitation to them. That limitation applies both to the number of assessments that can take place as well as to the location of the assessment. So the assessment itself must be conducted in a reasonable manner. For example, the insured person cannot be required to travel all the way to Toronto if the assessment could have been held in Windsor. Subsection 4 indicates that the assessment can be done by way of a written assessment based on the medical records submitted to the assessor, so it does not have to be an in-person assessment. There are certain rules that apply to these assessments that must be adhered to. The first is that if the assessment is to be a paper review, both the insured person and the insurer must provide the assessor with all relevant documents within 5 days of receipt of the notice of assessment. The second is that if the attendance of the individual insured person is required, first and foremost, all relevant medical documents must be required or must be provided, and the insured person must attend the examination and in doing so submit to all reasonable tests that are required. Now, with respect to the continued entitlement to income replacement benefits, non-earner benefits, and caregiver benefits, there are some additional rules that relate to assessments. Those are found in Section 37 of the SABs. So where an insured person is in receipt of one of these specified benefits, These rules must be followed to determine if the insured person continues to be entitled to the benefit. So, if the insurance company wishes to do an assessment of the insured person, they must first, and you can see this in sub A, request that the insured person submit within 15 business days a new disability certificate. Now that's that OCF3 form that I talked about a few minutes ago that is completed by the individual's physician. The purpose of this is to give the insurance company and their assessors updated information as to the individual's current condition, diagnoses, and the physician's opinion on the various disability tests. The second thing that must be done is notice must be given to the insured person that an assessment is required under Section 44. Both of these requirements must be met before a benefit can be terminated, specifically one of these specified benefits, the IRB, NEB, and caregiver benefit. The insurer cannot simply stop paying these benefits just because it does not think the individual complies. It is imperative that they comply specifically with Section 37. The insurer cannot discontinue paying a specified benefit to the insured person unless the insured person does not submit an updated disability certificate, or D, fails to attend a Section 44 examination, or E, has resumed his or her pre-accident employment. These are the only circumstances in which the benefit can be terminated. This prevents, basically the insurer from unilaterally terminating the benefit where the insured would otherwise qualify for it. Section 37, subsection 8 deals with the situation where the insured person subsequently, after a termination, complies with subsection 44.9, and it mandates that the insurer must reconsider the insured's entitlement to the benefit. So, think of the situation where disability certificate is not provided and 30 days later is provided. That doesn't mean the person is out of luck. The insurer is required to reconsider the individual's entitlement. Now, if the insurer determines that the insured person is still entitled to the benefit after reconsidering, the insurer is required to resume payment of the specified benefit and pay all amounts, if any, that were withheld during the period of non-compliance if the insured person is able to provide a reasonable explanation for not complying. So, for example, in the case of a disability certificate, perhaps the doctor was off sick and unable to complete the document. Or in the case of a missed assessment, maybe they got into, a car accident and was unable to attend. So there must be some reasonable explanation to pay those arrears. Otherwise, what happens is the benefit will be reconsidered and paid from the point of reconsideration forward, and the person will not receive the arrears that we're owing. Now, another right that the insurance company has is to conduct an examination under oath. This is very similar to the examination for discovery you would see under, for example, the rules of civil procedure. Basically, what happens is the insurer, whether it be an adjuster or a lawyer, is entitled to sit down with the individual insured person and ask them a number of questions about their injuries, the accident, and various benefits to which he or she may be entitled. Now, this right, though, is not unfettered. The examinations are limited to only one examination in respect to the same accident. So in essence, the insured person gets one kick at the can. The other thing is that the insurer is not entitled to examine someone who is incapable of being examined under oath. So if, for example, the individual is in hospital or has a severe brain injury and cannot attend an examination under oath, there is no right to same. During the course of the examination under oath, the insured person is entitled to be represented by counsel. There is no recovery for the cost associated with this. It would be at the insured person's own expense. But provided they can afford to obtain a lawyer, they can have a lawyer present during the course of the examination. Now, this is certainly an access to justice issue when the individual cannot afford to hire a lawyer, and there are certainly insurance companies that do take advantage of that. Most of them do know their rights and obligations, but it is definitely an access to justice issue. If we were going to look at fairness here, you would think that the government would mandate that if an insurer is to do an examination under oath, the insurer would ensure that the individual is represented by counsel. But unfortunately, that's not the case. When the insurance company schedules an examination under oath, they are required to make reasonable efforts to make sure that both the time and location of the examination are convenient for the individual. They are also required to give advance notice of the examination, including the date and location. They're required to tell the insured person that they are entitled to be represented by counsel. They have to give the reasons for the examination. So if it is to determine entitlement to the income replacement benefit, that has to be outlined in the reasons. And they're also to direct what the scope of the examination will be limited to, specifically matters that are relevant to the entitlement to benefits. This must all be included on the notice that is provided to the individual. Now, the insurance company is not liable to pay a benefit during any period in which the insured person failed to comply with a request for an examination under oath. So if the insured person fails to attend a scheduled examination, they will be noted in non-compliance, and the insurance company will not be required to pay their benefits. This is, similar to putting them in non-compliance and includes cooperating with the booking of the assessment. So if they are difficult with getting it booked, they could also be noted in non-compliance. However, if the insured person does subsequently comply, the insurer must resume payment of the benefits. And that is found in subsection 8. The benefit will be resumed, and the insurer is obligated to pay all amounts that were withheld if the individual provides a reasonable explanation for the delay in complying. So we've talked about all of the forms that go back and forth between the insurance company and the insured individual. And all of those go into this big pile, and they ultimately emanate in what we call an OCF 19 explanation of benefits. This is the insured company's decision with respect to the claim. So when any benefit is requested, the insurance company is required to deliver an OCF 9 explanation of benefits. They have to put in writing their decision with respect to the benefit request and the reasons for that decision. If the decision is that they approve the benefit, the treatment then can commence, or the payment, for example, is made. But, and this is where we get into the meat and potatoes of this class, what happens if the insurance company refuses to pay the benefit? And it is really this OCF 9 explanation of benefits that triggers the dispute resolution process. So, dispute resolution. The insurer and the insured person do not agree. Now what? Like most aspects of auto insurance, there are detailed rules that set out what the insurer and the insured person must do and how a denial can be disputed. Now, there have always been detailed regulations setting out the procedures applicable to SAVs. It's important to know that claimants cannot opt out of these dispute resolution procedures. They are required to follow them. Similarly, a claimant cannot simply file a court proceeding and sue their insurer. The current dispute resolution rules prohibit court actions. They require that all disputes be dealt with by the License Appeal Tribunal. Now, the current dispute resolution rules that we have today came into effect on April 1, 2016. At that time, the entire system was revamped. So for the purposes of today's class, what I'm going to look at is the dispute resolution procedure as it was prior to April 2016, the reason for the changes that came about in 2016 and how they came about, and then the current dispute resolution procedure, where we are specifically today. So if we look at the then, so prior to April 1, 2016, and the now, April 1, 2016 and beyond, I've put the chart on the screen to show you the difference. So then we were dealing with the Financial Services Committee of Ontario. They were the ones that were dealing with all disputes related to auto, or insured persons also had the option of filing a claim in Superior Court. So it would basically be a civil action that would be filed in the Superior Court of Justice. Now, what we're dealing with since April 1, 2016 is strictly the License Appeal Tribunal. All disputes have to go to the License Appeal Tribunal and are to be dealt with only by them. So let's do a little bit of a history lesson here and look at the then, what the dispute resolution process was like prior to April 1, 2016. And so up on the screen, I've basically outlined the procedure. So what would happen is the insured person would receive that OCF 9 explanation of benefits, and it would include a denial of a benefit. Once a benefit has been denied, the insured person would be allowed to apply for mediation at the Financial Services Commission. And so there was a specific form that needed to be completed. They would apply for mediation, and then the insurance company would deliver a response to the application for mediation. The mediation would then be held. Well, the difficulty that we had before April 1, 2016 is that the Financial Services Commission was very much backlogged. So mediations were taking sometimes 18 months to get a date. And so because of that, and the fact that mediations were mandatory, so you could not proceed beyond by litigating or arbitrating until you held the mediation, a lot of denials were really being held up. So, think of an individual who needs physiotherapy. It gets denied by the insurance company, and they have to then wait 18 months for a mediation that may or may not succeed. It was really an access to benefits issue that was not working out in the best interests of the insured persons. Once mediation would take place, the mediator would issue a report Once that report was received, then the individual insured person had the choice, and the choice was theirs alone, as to whether or not they would file a claim in the Superior Court of Justice and litigate, or would they file for arbitration at the Financial Services Commission. Now, Section 281 of the Insurance Act sets out the timeline for a dispute to be filed. And basically, there are 2 years in which to file a dispute from the denial of a benefit. So under the old system, the insured person had to file for mediation within 2 years of the denial. Under the current system, the individual has to apply for arbitration at the License Appeal Tribunal within 2 years. And you can see the sections that deal with mediation at the Financial Services Commission on the screen, 281 sub 2 and 281.1. And that specifically deals with that 2-year limitation period to file for mediation under the prior system. Under the old system, it was the mediator's report that determined when the individual could proceed to arbitration or litigation. That report was mandated by Section 280 of the Insurance Act and was to include a number of items. First and foremost, they had to set out the insurance company's last offer and describe the issues that remained in dispute. They contained a list of materials requested by the parties that have not yet been produced and that the mediator thought were necessary for the settlement of the issues. And they would also contain a recommendation as to whether or not the dispute should be referred to a neutral evaluation. A neutral evaluation was another step that was available prior to arbitrating and litigating, where the parties would get the opinion of a neutral person as to whether or not they would succeed at arbitration or litigation. It was, however, something that was not frequently used. Now, under the old system, there was the Dispute Resolution Practice Code that set out the procedures with respect to mediation and arbitration at the Financial Services Commission. And that practice code had a number of rules specific to mediations and the timing within which those mediations are to be conducted. Rule 19.1 indicated that mediation must be concluded within 60 days of the filing for mediation. Now, as I mentioned a minute ago, this was not happening. It was taking often 18 months or at least 12 months to secure a mediation date. This meant that people were waiting an inordinate amount of time to have their disputes resolved. Now, Rule 19.2 allowed the parties to extend the 60-day time limit for mediation, but in reality, there was no need to do that because the Financial Services Commission was unilaterally doing it. One of the reasons that SABS disputes are so strictly legislated is because there is an impetus to ensure they are resolved quickly and with very little expense. Not all insured persons have lawyers to assist them, and the system is really supposed to be designed for these people to advocate for themselves, to not require a lawyer to go through the process. Unfortunately, what was happening under the old system is that these disputes were not resolved quickly and the backlog was just outrageous. I have some stats from 2011. The Financial Services Commission received 36,492 applications for mediation. On April 1, 2012, 21,023 of FSCO's applications were more than 60 days old. it was a really tough system to be in because you couldn't get to the courts without filing this application for mediation, but then your hands were tied for months on end. To get around this issue, some people tried to skip the mediation process altogether and proceed straight to arbitration and to the Superior Court while they were waiting for the mediation date. So basically what they did is they would file for mediation, and while they were waiting, they would file their statement of claim in Superior Court. But the difficulty with this is that the Superior Court and FSCO said this is not how it works and that we can't proceed that way. So there was no mechanism to save time here. We were all stuck in the backlog system that was FSCO at the time. Now, one of the things that FSCO tried to do to help with this problem was to enable the parties to fail a mediation without attending. This way they could just consent, to move forward to the next step. The difficulty that a lot of people, though, had with this is some insurers would refuse to consent, which would, leave the plaintiff's hands or the insured person's hands tied. But then even if there was consent and the parties were allowed to move on to arbitration, there was a similar backlog in the arbitration group at FSCO where you were waiting months on end to have your case heard there as well. So the system was really broken. It just really was not working. Things were not moving forward, and it became incredibly difficult to resolve these cases. Once you were able to obtain a failed mediator's report, the parties then had the option of neutral evaluation if it was directed by the mediator, or they could elect to proceed to arbitration or Superior Court. Now, arbitrations were conducted by the Financial Services Commission, and often people would elect to proceed through an arbitration as opposed to through a court hearing because, for one, arbitrations had the potential to be much faster until we sort of hit the issues with FSCO's backlog, in and around 2010 and beyond. The other reason that people would often elect with an arbitration is because the arbitrators at FSCO specialized in accident benefits. This is all they did. They were trained, they lived and they breathed accident benefits. Whereas if you were going to the Superior Court with these issues, there would be time that needed to be taken to educate the judge on the issues and the statutory accident benefit procedure. If an individual were to file for arbitration, the process is what's set out on the screen. The application form would be completed. It would be submitted to FSCO. The insurer would then file a response within 20 days. The insurer would be charged a $3,000 assessment fee. There was no fee to the applicant. FSCO would then book a pre-hearing discussion. It was supposed to take place within 6 to 8 weeks, but again, it didn't, typically in the latter days of FSCO. That pre-hearing discussion would be scheduled in order to try to resolve the issues or narrow the issues and set out the issues for the hearing. The arbitrator would then schedule the hearing during the pre-hearing, and again, it was supposed to be booked within 4 to 6 months, but this did not always happen. There would also, in advance of hearing, typically be a settlement discussion, usually, a week or so before the hearing, to see if there was any last-minute effort that could be undertaken to resolve the issues. What's important with respect to arbitration is that only the insured person had the right to file for arbitration. No such right existed with the insurance company. Under the new system, the insurance company now has the ability to file for arbitration against insured persons. So as an example, I had a hearing that was to be held in the fall, and we were dealing with catastrophic determination. While my client was also in an overpayment situation with respect to her income replacement benefits, the insurer had paid her these benefits throughout her claim, terminated them about a year prior, and subsequently new law came out, which, because my client was self-employed, indicated that the insurer had paid more than it should have had to. So my client was in a $30,000 overpayment situation. She did not have the money to pay that overpayment. And we were in the midst of a catastrophic dispute. And so what the insurance company did is they filed a claim at the License Appeal Tribunal against my client, seeking to recover the $30,000 in arrears. And so it really became a strategic advantage on the part of the insurance company because, of course, it scared my client into taking, a lower offer than I think my client probably should have in those circumstances. But previously, under the old system, there was no ability for an insurance company to bring a claim against an insured person. Arbitration decisions were not final. There was a right to appeal or to have them varied or revoked. Section 238 of the Insurance Act indicated, though, that insured persons and insurers could only appeal the arbitrator's decision if the arbitrator made an error of law. Questions of fact could not be appealed. There were also rights to vary or revoke a decision. That was found in Section 284 of the Insurance Act. And it was appropriate where, for example, the insured person's situation changed since the arbitration hearing, or new evidence had become available that was not available at the time of the hearing, or if there was some clear error in the arbitration decision. In those cases, there could be an application brought to either vary or revoke the decision. Now, as I mentioned, insured persons had the option of both arbitrating or going to the Superior Court of Justice. If they chose to proceed to the Superior Court of Justice instead of arbitrating, it would be treated similar to any other Superior Court of Justice case. So they would file a statement of claim in the Superior Court. There would be defenses filed. There would be an examination for discovery, followed by mediation if it was required in the jurisdiction, a pretrial conference, and then ultimately the trial. And of course, depending on the value of the benefits in dispute, the individual could proceed to small claims court, simplified rules, or the regular track. One of the big differences, though, with the Superior Court proceedings is, as I mentioned, the judges do not specialize in accident benefits. So there is an element of needing to educate the judge as you go through the process. And you're also going through a typical civil litigation process, which can often be very lengthy and timely. So, this is typically where I would ask the class to give me their thoughts on which process would be more beneficial, whether it be arbitration or Superior Court. There are a lot of differences between the two, but there's also similarities. And so if you look at the chart on the screen, with arbitration, the Dispute Resolution Practice Code sets the rules of the road. Whereas with Superior Court, the rules of civil procedure set the rules. With arbitration, you're dealing with FSCO. Superior Court, you're obviously dealing with Superior Court. With arbitration, you're dealing with, again, those arbitrators who only adjudicate AB disputes. They specialize in this area and they probably know the dispute resolution practice code better than any other counsel. In the Superior Court, the judges are not as familiar. SABS disputes are not the typical disputes that they would see, and it can be a very, very complicated process and system for someone to learn. In arbitration, there is no right to a jury, so those disputes would be only heard by the experienced arbitrator. In the Superior Court, there is a right to a jury trial, and that certainly can complicate the dispute and make it much more costly. With arbitration, timelines do mandate that this happens faster and you get from start to finish in much less time, with the pre-hearing to be held within 6 to 8 weeks and arbitration in 4 to 6 months. In Superior Court, you're dealing with examinations for discovery. There is no right other than that one right to an examination under oath, to an examination in the arbitration scheme. There's also the mediation, pretrial conference, and then trial that you deal with in Superior Court. So even with the backlogs that existed when FSCO was last in place, often arbitrations could still happen faster than you would see them happen in Superior Court. Also under arbitration, documents are to be exchanged in advance of the pre-hearing, and expert reports are to be served at least 30 days prior to the arbitration hearing. In Superior Court, there are different rules with respect to expert reports, but they're generally similar. There is, under the arbitration scheme, no right to examine a representative of the insurance company, whereas in Superior Court, there would be a right to do an examination for discovery of the insurance adjuster. This would be important if there was an issue of what we call bad faith, where the individual claimant indicates that the insurance company treated them unfairly and is seeking either punitive damages or a special award. In arbitration, the insurer does have that right to do the examination under oath pursuant to Section 33. Both the arbitration and the Superior Court of Justice system held and holds pre-hearings and pretrial conferences. So that is very similar. There's a slight difference in terms of the number of experts allowed under each system. It's 2 for the arbitration process, 3 for the Superior Court process. There is some flexibility with that, as it's often interpreted as being 2 or 3 experts per issue, as opposed to in total. There's often a difference between the two systems with respect to the length of hearing. Arbitration's hearings were typically limited to 2 to 3 days, whereas hearings in the Superior Court often go on longer than that, especially if you're dealing with a jury. And then both systems also had the ability for motions to be brought. So as an example, a motion could have been brought for interim payment of benefits. If, for example, the income benefit is terminated and the individual is in dire need, you could bring that motion for interim payment. There is also a difference between the two systems in terms of the cost involved. Arbitrations can be much more inexpensive than a Superior Court trial, which can often be very costly. In the same vein, though, the costs that you can recover at an arbitration were very, very limited. For example, the counsel fees recoverable were very similar to legal aid fees. Expert reports, the quantum recoverable was capped. Even experts' attendance at trial or at arbitration was capped as well. Superior Court has much more leeway and flexibility in terms of the costs that could be recovered at the end of the day. Both systems had something akin to punitive damages. And you may have heard of punitive damages in your torts class, for example. Basically, punitive damages are meant to punish the tortfeasor for having done something wrong. So Superior Court, there's no real restriction on the quantum of punitive damages that could be awarded. Arbitration has something akin to punitive damages, which is special awards, and there were monetary limits on what could be recovered there, and we will talk about that later in this lecture. There were also, as I said, there were appeal rights with respect to both as well, but under the arbitration system, only an error of law could be appealed. So before I move on, let me just recap. It was always a difficult decision as to whether or not you brought a dispute to the Superior Court of Justice or to FSCO. And it was a decision that we often struggled with as lawyers, what would be most advantageous to our clients. Lawyers often tended to prefer the Superior Court because they were comfortable and familiar with it, and most lawyers had experience in Superior Court. Whereas FSCO, unless you practiced exclusively in that area, you didn't have as much of a comfort level there. At the same time, insurance companies tended not to like disputes in FSCO, or rather prefer going to Superior Court, because the FSCO arbitrators, as I said, specialize in the accident benefits, and they understand the duty of good faith, the duty for the insurance company to help the insured person. And so often these FSCO arbitrators would focus very strongly on the rights of the insured persons and find in favor of the insured. And for that reason, insurance companies preferred not to be dealing with them. I tended to prefer the arbitration realm. I found even with the backlogs that it was still faster than the court process, and there were much less steps involved, but it was sort of an unknown area to a lot of us. Now that we don't have that decision, you look back and I think, regardless of the fact that the decision was difficult, at least the individual claimant had the choice. Whereas now the government has taken away that choice, left us with the License Appeal Tribunal, who, when we talk about them later in this lecture, you'll see are not experienced in this area. And because they've taken away the right to go to court, there are some options and remedies that are now off the table. But regardless of all of that, it was clear there was, however, a need for change. At the time, the system was not working. The backlog was just getting bigger and bigger rather than better, and it was becoming more and more difficult to resolve cases. So in 2012, as part of the provincial budget, the Ontario government announced a review of the auto insurance dispute resolution system. They wanted to reduce auto insurance rates by 15% within 2 years. In August of 2013, the Minister of Finance, Charles Sousa, appointed the Honourable Mr. Justice Cunningham, who was the former Chief of Justice of the Ontario Superior Court of Justice, to conduct the review. The review was really part of their plan to reduce the auto insurance rates in Ontario. Justice Cunningham released his interim report in October 2013 and called for submissions from the auto insurance stakeholders, the insurers, the plaintiff groups, the victims' rights advocates, and so on. Justice Cunningham's final report was released on February 18, 2014. That report included 28 recommendations for change. Justice Cunningham's report contemplated dispute resolution principles of timeliness, proportionality, accessibility, predictability, and cost. He wanted the disputes to get resolved quickly, simply, and efficiently. Basically, his report, in essence, indicates that it should provide quick access to the system, accommodate different processes based on the complexity of the case, similar to sort of the small claims, simplified procedure, regular tracks that are available in the court system. He wanted the system to be accessible, regardless of whether represented by a lawyer or not, so that individuals could find their way through the system without needing a lawyer. He wanted outcomes to be predictable, and he wanted the process to be quick and simple. He wanted it to be cost efficient, and he wanted a process that encouraged early resolution. Justice Cunningham envisioned a system that would take no more than 6 months from start to finish. If this system were to be put in place and were to accomplish the goals that Justice Cunningham had, which are to some degree questionable, this would have been a huge improvement from what we were dealing with back in 2013. This is a chart from Justice Cunningham's report, and it outlines the system that he envisioned. It obviously starts with the company denial that you can see at the top of the screen. He wanted the insurance companies to establish a formal internal review process. And you can see that review process is in blue also at the top of the screen. He wanted to give them 30 days after receiving notice of a dispute to reconsider the decision. And he wanted a written response to then be provided to the claimant within 30 days with the outcome of the reconsideration and the reasons for the final decision. He then wanted to allow for the claimants or the insurance companies to apply for a settlement meeting. And he wanted that settlement meeting, as well as the remainder of the dispute resolution system, to be done by an independent tribunal. He did not want FSCO to continue handling disputes. The reason being is he felt they were too interconnected with insurance companies, and he wanted there to be a public sector administrative tribunal that dealt with those disputes. He wanted the new model to fall under a minister rather than the superintendent of financial services. As you know, the Financial Services Commission sets insurance rates and is very intertwined within the insurance industry. And so Justice Cunningham really wanted there to be a separate independent tribunal. And he wanted arbitrators to be appointed by order in council on the recommendation of the minister of that tribunal. Justice Cunningham also recommended that all SABS disputes be resolved by this independent tribunal. He did not want insured persons to have the option to take a dispute to court. He wanted all disputes to remain with the independent tribunal. He also recommended that neutral evaluation be eliminated. It had not been used in a number of years, and so he recommended that it be removed from the regulation. He also wanted statutory timelines to be created and those timelines to be followed unless there were exceptional circumstances. He indicated that this means that matters should not be adjourned without cost consequences or sanctions. If someone is ready, if someone is not ready and unable to proceed, they would lose their right to costs if they succeeded at the hearing. He also indicated that applications should be vetted by a registrar. There should, in essence, be a gatekeeper who reviews all applications and makes sure the parties are ready. And that the registrar would deal with production issues and other preliminary matters to ensure that the parties are ready to go and that these disputes can move quickly. In terms of application fees and filings, he recommended an electronic filing system and continued to endorse the current policy at the time that there be no application fees for claimants at the start of the process. He indicated that the system should be accessible to claimants and they should not have to pay to proceed through the dispute resolution process. Then he recommended that there be a settlement meeting. He recommended this would be in essence to the mediation that existed under the previous system, but it would be called a settlement meeting and it would not be conducted by a mediator. It would instead be conducted by an arbitrator. In essence, what he did was combine the mediation with the pre-hearing discussion so that instead of there needing to be two steps, there would only be one, and they would address all the issues that the two separate steps previously addressed. He recommended that the settlement meeting take place within 45 days of an application being accepted by the tribunal's registrar, and that during the settlement meeting, a non-binding opinion of the likely outcome should be given to the parties. If there was no settlement affected at the meeting, he wanted the parties to disclose the evidence they intended to rely on at the arbitration. He also indicated that the arbitrator who conducted the settlement meeting should not conduct the arbitration. If the settlement meeting fails, he indicated that the parties would then apply for arbitration. At arbitration, he proposed a three-tiered system, basically that the files be triaged by the arbitrator into an appropriate stream based on the complexity of the issues in dispute. He wanted this process to be informal. He did not want there to need to be a hearing to determine which format applied. He also wanted the decision of the arbitrator as to the appropriate stream to be final and not subject to appeal. Now, the three streams you can see at the bottom of the screen, they were paper review, in-person expedited hearing, and in-person full hearing. The paper review was, per Justice Cunningham, to be done within 60 days of receipt of the completed arbitration application. He wanted the decision to then be made within 30 days of the date of review. And he wanted the length of expert reports and briefs to be limited to no more than 3 pages. Now, he did discuss the types of cases that he thought should fall under the paper review scheme and indicated that these are the simpler, more straightforward cases where there's not a lot of money involved. So, the denial of a physiotherapy treatment plan, where the cost to do a hearing would far exceed the cost of the treatment plan. He also recommended any dispute worth less than $10,000 and MIG determinations be dealt with under this stream. Now, his recommendation on MIG determinations was very controversial at the time because even though the MIG limits are only $3,500, the determination as to whether someone falls in the MIG or in the non-catastrophic category is the difference between $3,500 and $65,000. And for that reason, a number of people had an issue with that particular recommendation. In terms of the expedited in-person arbitration hearings, these would sort of be similar to the simplified rules system in the Ontario courts. And he wanted these expedited hearings to be used for straightforward disputes that require an oral hearing. He wanted the decision to be made by the arbitrator, and he wanted them not to be subject to appeal. He basically wanted the length of the hearing to be limited, as well as the number of reports, and he wanted the hearing to be held within 90 days of the receipt of the completed application. For the full in-person hearings, he wanted these to be reserved for the more complicated disputes. So catastrophic determination, income replacement benefits beyond 104 weeks, and 24-hour attendant care claims. He again wanted these to be held within 90 days of receipt of the completed application, and he wanted the length of the hearing to be determined by the arbitrator, and for the arbitrator to provide written reasons for his or her decision within 45 days of completion of the hearing. Justice Cunningham also talked about expert reports and indicated that they should be required to certify, that the experts should be required to certify their duty to the tribunal, similar to Rule 53 of the Rules of Civil Procedure. They should indicate that they are preparing a non-biased report and they understand that their duty is to the tribunal as opposed to either of the parties. And that's something that didn't exist before Justice Cunningham's recommendations and really before April of 2016. And he thought that it would be important to include that in the system. He also talked about the arbitration decisions. He found that they should continue to be published for predictability reasons. By that he means he wants everyone to see how the tribunal has determined similar issues in the past, and for the tribunal to be aware of that so that there is some predictability in the system rather than a bunch of cases all going in different directions. He did indicate, though, that the tribunal decisions should not be binding. They should, however, only provide guidance to the arbitrator, and that the purpose of the dispute resolution system is to resolve disputes, not to create case law. In terms of costs, he didn't suggest any amendments from the prior system. He did think that there should be something similar to Rule 49 of the Rules of Civil Procedure, where the parties are penalized for not accepting a reasonable settlement offer. He also thought that set fees should be established for settlement meetings and the different streams. So, for example, if it's a paper review hearing, there should be a limited amount of costs available for that, and that limited amount should obviously be less than an in-person full hearing. If it's a settlement meeting, there should be a set amount available to recover for that. In terms of appeals, he thought appeals should be made to the Superior Court, and you can see that in purple at the bottom of the screen. At the time, appeals were being made to the Director's Delegate of the Financial Services Commission. He wanted us to do away with that and recommended that they instead go to the Superior Court. He also suggested that the courts should set up something similar to the commercial list and appoint a specific judge to hear these types of appeals so that that judge is well versed in this area of the law. In terms of settlement, and we'll talk about this in a minute, but there was currently a prohibition on settling claims within the first year after the accident. He wanted that prohibition extended to 2 years post-accident so that claims could not be settled until at least 2 years went by after the date of the accident. Now, at the time, there was a lot of debate in the industry regarding Justice Cunningham's recommendations and expected changes. The insurance industry said it did not go far enough, whereas plaintiff advocates often said it went too far. Plaintiffs groups were most concerned with Cunningham's recommendation that the right to sue in Superior Court be eliminated. This would mean, as I mentioned, that all disputes would have to go to arbitration. It's also difficult because it would eliminate the ability to do an examination for discovery, for example, of an insurance representative. I would eliminate the right to punitive damages, and costs are recoverable at a higher rate in the Superior Court. All of that would no longer be available if that recommendation was adhered to. The other concern was the implementation of a public administrative tribunal. It was a good recommendation in the sense that it would eliminate any perceived pressure on adjudicators from the Financial Services Commission and certainly boost the confidence in the impartiality of the dispute resolution system. But the concern amongst plaintiff groups was, would that tribunal maintain the specialization that FSCO had? As I said, they lived and breathed statutory accident benefits, and the plaintiff groups wanted to make sure that any independent tribunal continued to do that. The specialization, experience, and familiarity is very important to the ongoing system. The other concern related to appeals. Currently, at the time, the appeals were being made to the director's delegate, whereas Justice Cunningham was recommending they go to the judge, to a judge of the Superior Court. But again, the concern with that was that the Superior Court does not specialize in these issues where the director's delegate does. And so by taking that special knowledge out of the equation, it could make the appeals much less fair and more difficult. And then the last issue that they tended to have related to paper reviews for MIG determinations. And as I said, that there's a lot of money involved when you're dealing with a MIG determination. And so that would not be something that they would want to deal with as a paper review only. Now, the government did determine that change was needed, and they did certainly make some change. What ultimately ended up happening, though, was not fully what Justice Cunningham was proposing. The government did take some of Justice Cunningham's recommendations, but certainly not all of them. So on July 15, 2014, the Ontario government introduced Bill 15, Fighting Fraud and Reducing Automobile Insurance Rates Act. This is basically a combination of two earlier bills that died during the spring election call. Royal assent was received on November 20th, 2004, and in essence what it is a bare bones revamp of the dispute resolution system. The Act moves the administration of the dispute resolution away from the Financial Services Commission to the Ministry of the Attorney General's License Appeal Tribunal. So in one sense, they took Justice Cunningham's recommendation that an independent tribunal be created. In doing this, it was submitted by the government that it would help cut down on consumer frustration, as well as curb financial and administrative stress on the system. And it was really trumped by the government as something that would be a win-win situation. This is an excerpt from the bill that talks about the movement to the License Appeal Tribunal. And at the time, the License Appeal Tribunal was a relatively unknown body, at least to those of us who practiced automobile insurance law. It was really an adjudicative agency that was created in April of 2000 under the License Appeal Tribunal Act. And its mandate was to provide a fair, impartial, and efficient means to appeal decisions concerning compensation claims and licensing activities regulated by several ministries. So it didn't specialize just in accident benefits. It also regulated disputes at the Ministry of Education, the Ministry of Children and Youth Services, the Ministry of Community Safety and Correctional Services, the Ministry of Consumer Services, and so on. There's a whole long list of ministries for which the License Appeal Tribunal dealt with. And it received appeals, conducted hearings, resolved disputes, and rendered decisions on compensation claims and licensing activities regulated by all of these ministries. So, one of the biggest fears that came out of this bill was we've now lost the specialty that the Financial Services Commission had. And how would the License Appeal Tribunal handle these disputes? Would they follow the law that was previously set by FSCO? Would they create new law? Would they go off on a different tangent? And there really was at the time a lot of uncertainty. So the dispute resolution change became effective on April 1, 2016. And this slide up on the screen right now really deals with what I've just said about what the License Appeal Tribunal was. So effective April 1, sorry, I might have just said June, effective April 1, 2016, the License Appeal Tribunal was to handle all SABS disputes. The FSCO dispute resolution system was eliminated, and under this new system, though, all disputes were expected to be resolved within 6 months. The government also eliminated the right to court proceedings, and you can see that at the bottom of the screen. No person may bring a proceeding in any court with respect to a dispute described in subsection 1 other than an appeal from a decision of the License Appeal Tribunal. So it really restricted these claims solely to this unknown License Appeal Tribunal. The legislation also indicated that all disputes, though, were still to be resolved in accordance with the statutory accident benefits schedule, and that the government may provide regulations to deal with the procedures involved in the hearing and issues such as costs. As part of the new resolution system, the government did revise the Insurance Act to allow for the government to pass regulations with respect to various orders, including interim orders, orders to pay costs, orders regarding a person representing a party to pay costs personally. Under the old system, costs were available in much the same way that they are currently available under the rules of civil procedure. It was, in essence, a loser pay system where whoever won would be entitled to costs from the other side. The expectation with the new dispute resolution system was certainly that costs would stay the same. Justice Cunningham certainly recommended no changes to the cost system and recommended that costs remain in place. Unfortunately, what has happened, and we'll talk about this a little bit further in a minute, is that there were drastic changes made to the costs that are recoverable in a LAT hearing. And because of that, we are now operating in a no-cost system. And as I said, we will get to that in a moment. Now, I just went through the various stages that Justice Cunningham recommended. Those stages were not fully adhered to as part of this new protocol. Instead, here's the stages that we have if you're filing a claim or proceeding through the License Appeal Tribunal. Number 1, the insured person completes an online application applying for arbitration and must now pay a $100 application fee. As you'll recall, there was previously no application fee payable by the insured person. The insurance company then has to file a response to the application that is to be filed within 10 days of receipt of the application. Once the LAT receives both of those documents, they will schedule a mandatory case conference. Everyone is required to attend the case conference. They're often held by telephone if you're not based in Toronto, or they can be held in person for those who are based in Toronto. The case conference is very similar to the pre-hearing discussion and the mandatory mediation that previously took place. In line with Justice Cunningham's recommendations, it is an arbitrator who conducts the case conference as opposed to an independent mediator. And the case conference is really an opportunity to, number one, try to resolve the claim in line with the mediation that was previously available under FSCO, as well as to schedule the hearing, set out the issues for hearing, and deal with any document productions. That case conference is supposed to take place within 45 days of receipt of the insurer's response. There is a bit of a backlog currently, and that is unfortunately not a timeline that is typically being adhered to. At the case conference, if the parties are unable to resolve the dispute, the hearing will then be scheduled. And the hearing can take place, or is supposed to take place, within 60 days of the date of the case conference. This, however, is another timeline that is not often being adhered to. I had a case conference recently, and the earliest hearing date I could get was 6 months from the date of the case conference. So there is certainly a backlog similar to the backlog that we dealt with under the Financial Services Commission, and that backlog seems to be growing on a regular basis. With the issues with the coronavirus, the License Appeal Tribunal has placed on hold all in-person hearings, which I expect will even further increase the backlog once things resume and return to normal. With respect to hearings, the License Appeal Tribunal does have the ability to conduct hearings in a number of different ways. So this is certainly in line with Justice Cunningham's recommendations that hearings should be dealt with in the most expeditious and cost-effective manner. And as you'll recall, Justice Cunningham recommended 3 modes of hearing: the paper review, in-person expedited, and then the full in-person. And I can tell you that the License Appeal Tribunal is utilizing those potential avenues in ways that I think have been beneficial here. A lot of these hearings will take place in writing if the parties both consent. So on simple issues, if you're just dealing with a treatment plan or it's more of a legal issue, the parties will typically proceed for a written hearing. When it's a more significant issue, such as ongoing income replacement benefits or catastrophic determination, or even MIG determination, the parties will often opt for a in-person hearing. One of the other things that the License Appeal Tribunal is doing, which is quite helpful, is they will do combination hearings where part of the hearing will be done in writing and part of the hearing will be done in person. That really has proven to save costs as well as time. Now, the important thing to remember here is this is the only avenue available to now address SABS disputes. The parties can no longer bring their dispute before the courts. The only option to address it is to file an application with the License Appeal Tribunal. One of the difficulties with the tribunal is we have now lost that specialization that the Financial Services Committee had. The adjudicators at the License Appeal Tribunal are not all well versed in the SABs. They certainly have some training when they are hired, but they come from all kinds of different backgrounds. They are not all lawyers. They have not all practiced in this field. I had a case conference a few months ago with an adjudicator who has a real estate background. She, while trying to be very helpful, unfortunately did not have the knowledge base to help deal with the complicated issues that we were dealing with. So we have lost that really important part of the Financial Services Commission that was quite helpful in the past. One of the other issues with the License Appeal Tribunal is that they seem very rigid and not practical. So when they're looking at these timelines to advance a claim, they focus solely on that instead of looking at, practically speaking, what should happen here. So as an example, I had a catastrophic dispute. We were waiting on the insurer's medical assessments to be completed. They had sent my reports off to their own assessors and done some updated assessments. We were waiting for those to be completed, and we asked for the hearing not to be booked until we received those documents. So what we had asked for instead was for the case conference to take place once we had received all of those documents. Because without all of the medical reports, it's very difficult to resolve the case, and the case conference really wasn't of much benefit to us. The License Appeal Tribunal refused that request, even though it was on consent of both parties. And instead, what they did is they scheduled the case conference. We were obviously unable to resolve the matter because we didn't have all of the expert reports. And they booked the hearing. And they pushed us to book the hearing for a very early date, even though both parties said, look, we are very much trying to get these reports in, but we can't guarantee we will have them in time for the hearing. So what ended up happening is the insurance company's reports came in about 30 days before the hearing. My experts had to scramble to review and comment on them. And then I think I got mine in about 2 weeks before the hearing. And then the parties had to have a settlement discussion at that point. The difficulty is, and we were ultimately able to resolve the file, but the difficulty is that we had to do all the prep work in the lead up to the hearing because we didn't know if it would resolve or not. So there was no time available for us to try to save the costs of the hearing and try to resolve it instead. So I've given you a little bit of the pros and the cons of the current system, and the real million-dollar question here is, has the LAT, which is the License Appeal Tribunal, improved the dispute resolution system? We're now at about 4 years of experience with the License Appeal Tribunal. It started in April of 2016, and we are just approaching April of 2020. Unfortunately, I think all parties would agree that this experience has not been overly positive. Both insurers as well as individual claimants are not content with the system. There are a number of difficulties and issues, and the frustration level and concerns amongst stakeholders appears to be even higher today than it ever was. The Financial Services Commission certainly had its issues, but at least we were dealing with certainty in terms of their case law. They would, follow similar law. And we were dealing with a level of specialization that we certainly don't have here. So my answer to that question is definitely no. It has not improved the system. The main issues that we are experiencing is delay, seeming lack of impartiality, and I will talk about that in a minute. It's not accessible. We have moved to a no-cost system where even if an individual benefit is improperly terminated by the insurance company, the individual cannot recover their legal fees to fight that denial. And as I've already mentioned, the LAT is not always practical. So let's look first at the delay. When the LAT first took over disputes, things were moving quite quickly. I mean, they really had no backlog because FSCO dealt with the backlog that was already there, and the LAT started from scratch. So things did tend to adhere to that timelines, to the point that a lot of counsel were worried that things were moving too quickly. And it really truly was a refreshing change from the Financial Services Commission. If anything, at the time, the LAT arbitrators were often unreasonable in refusing adjournment requests, even if those requests were on consent, or there were legitimate reasons for needing the adjournment, such as in that catastrophic dispute that I mentioned. The LAT would still refuse them. It really became a difficult and unworkable system for this reason. But on the plus side, the matters were moving forward in a relatively timely manner. Now, in the last year or so, things have, however, changed dramatically. Many of the parties were experiencing widespread delay, with the LAT explaining that one of the reasons for the delay is the high volume of applications that they have been receiving. These are the operational statistics for the LAT. It's only current to Q1 and Q2 of the 2018-2019 fiscal year. But you can see starting in the 2016-2017 year, the LAT only had just under 6,600 cases or applications that were received. Those applications jumped to over 10,000 in the 2017-2018 year. And just in the first and second quarter of 2018-2019, there were 6,150 applications received. There are certainly more applications that are being received than are being closed, as you can see from the second row of the chart. There were a number of case conferences. Those numbers increased as well. If you look at just under 3,600 in 2016-2017 to nearly 4,400 in the first and second quarter of 2018 and 2019. My information is that these applications have continued to increase. I know, as I mentioned, my recent case conference, I was looking at a hearing 6 months from the date of the case conference. So it really is a difficult system where we're sort of getting right back to where we were with FSCO. So not only do we have the same delay issues that we had with FSCO, we've also got a tribunal that's not specialized, and we have a no-cost system. So, it's really hard to say we've made some progress here, given all of the difficulties. Now, the government, when the government changed from Kathleen Wynne's government over to the Ford government, there was another issue that led to the delay. The adjudicators are appointed by order in council, which means the government has to approve of their appointment. What happened when Ford took over in 2018 was he put a freeze on all new appointments and basically froze everything while he did an audit of all of the various government agencies. And because of that freeze, LAT adjudicator contracts were not being renewed. So there was a period of about 6 to 9 months where LAT adjudicator contracts were coming to an end without renewal, and we were significantly short-staffed. Because of this, the LAT was unable to keep up with the volume of work. Case conferences and hearings were being canceled at the last minute because there just weren't enough adjudicators, and staff members, because there were no new hires as well within the staff. So staff members were unable to keep up and prepare the adjudicators for the hearings and the case conferences. So we had a bit of our own pandemic at the LAT in 2018. That has since been resolved, but it did create a significant backlog, adding to the already existing backlog. The next issue with the LAT is impartiality, or rather lack thereof on the part of the LAT. There is a recent case that went all the way to the Court of Appeal that raised issues of impartiality as it relates to the LAT. Shuttleworth and Peel Insurance is the name of the case, and it was a LAT decision that was appealed to the divisional court and then subsequently appealed from there to the Court of Appeal. The Court of Appeal decision was released in late 2019. The case involved a catastrophic dispute, so the insured person applied to be deemed catastrophic. That was Mrs. Shuttleworth. The insurer denied her catastrophic designation, and Mrs. Shuttleworth therefore applied for arbitration to dispute the denial. The arbitration was held at the LAT in front of arbitrator Sapin. And arbitrator Sapin found that Mrs. Shuttleworth did not sustain a catastrophic impairment. The interesting thing here is that this arbitration was the first arbitration at the LAT dealing with catastrophic determination. A few months after the hearing was concluded, Mrs. Shuttleworth's counsel received an anonymous note. It sounds like something out of a spy movie, but in reality, this is what really happened here. And I'll show you the text of the note. So here's the note that Mrs. Shuttleworth's counsel received. This is the text that's found in the divisional court's decision. And the note reads as follows: I have heard from reliable source that the adjudicator Sapin's initial decision was that this was a catastrophic impairment. This decision then went up for review, and the executive chair, Linda Lamoureux, changed the decision to make the applicant not catastrophically impaired. Thought you should know that the decision was not made by an independent decision maker who heard the evidence. I was also told that the adjudicator Sapin hesitated to sign this order. Now imagine you're Mrs. Shuttleworth's counsel sitting in your law office and you receive this anonymous note and all the various things that were probably going through his head. It really truly does seem like something out of a spy movie. Linda Lamoureux, who I believe is still the executive chair, but I could be wrong on that, she is in essence adjudicator Sapin's boss. So the executive chair is in charge of all adjudicators at the LAT. So if this note is accurate, adjudicator Sapin's boss told her to change the decision. So typically, if there is an issue with a LAT decision and an appeal is going to be made, the first stage of appeal is to the executive chair at the LAT. So Mrs. Shuttleworth's counsel, had he followed sort of the rules of appeal, would have had to appeal this decision to Linda Lamoureux herself. And obviously, given the potential bias here and Ms. Lamoureux's involvement in it, the counsel for Mrs. Shuttleworth decided to instead apply for judicial review at the divisional court. And the divisional court found that that was certainly proper given the dynamic of bias that was being considered in this case. So Mrs. Shuttleworth's counsel applies for judicial review at the divisional court. And what we learn through the divisional court hearing is that the LAT had a seemingly secret, unwritten, mandatory internal review process. And I'll show you what that process was. So this here is an outline of that internal review process. So, obviously it first starts with the adjudicator writing his or her decision after hearing all of the evidence. Once the decision is written, the adjudicator then sends it for a peer review with the duty vice chair. And this is expected of the adjudicator. It is not something that the adjudicator can opt out of. All decisions are to be sent to the duty vice chair for review. The LAT's position is that the vice chair will offer suggestions to improve clarity, reasoning, and readability. Once that review is done, the decision will then go to the Legal Services Unit for a legal review. And their job is to ensure the correct legal test has been applied and to identify any case law not mentioned in the decision that may be helpful. In certain cases, the Legal Services Unit will then send the draft decision to the Executive Chair for review. This is apparently done in cases involving novel, contentious, or precedent-setting issues. And you'll recall that Shuttleworth was to be the very first catastrophic decision coming out of the LAT. And so because of that, it had the potential to be precedent-setting. And it was certainly a major issue. I mean, catastrophic determination are, one of the most complex and significant issues that we deal with in SABs. And so the Legal Services Unit in Mrs. Shuttleworth's case unilaterally sent the decision to the Executive Chair for review. This is done without consulting with the adjudicator. What the LAT said in the Shuttleworth's case is that the Executive Chair then provided comments to the adjudicator who revised and released her decision. What we do not know, though, is what those comments were or what revisions the adjudicator made. No evidence was presented on this point in Shuttleworth, and the LAT was not cross-examined. Now, I would argue, and I expect that Mrs. Shuttleworth's counsel argued, that if this was simply a review and a suggestion type situation, the LAT would have provided what those comments were. And provided some evidence from adjudicator Sapin that the decision was in fact made independently. The LAT certainly did not do that. And again, I would argue that if you can't put that forth, you must have something to hide here. Once the Executive Chair's review is concluded, the case or the draft decision would then be reviewed by the Case Management Officer. This is basically an edit of the document for grammatical or spelling errors and to ensure that the template and parties' names are all correct. The LAT's position in the Shuttleworth decision was that the reviewer is nothing more than an informed editor. The reviewer does not question the facts and evidence presented or comment on the decision's policy choices or outcome. The LAT further asserted that the adjudicator has complete discretion to accept or reject any suggested revisions. But again, no evidence was presented by adjudicator Sapin to refute the anonymous note that was provided. Ultimately, the divisional court heard all of the arguments and all of the evidence that was presented and really disagreed with the LAT's assertion that the internal review process was appropriate. The divisional court held that the process created a reasonable apprehension of a lack of independence. The divisional court based its decision on three main issues with the LAT's process. The first is that it failed to comply with the LAT's statutory obligations. There was no formal or written policy that protected the adjudicator's right to decline to participate in or to decline to make the changes proposed by the Executive Chair. In fact, the LAT had no written policy whatsoever. The entire process was unwritten, such that the court was, as a result, provided with no assurances that the arbitrator was independently making its decisions. The second issue the court had with this process was that it was not voluntary. The adjudicator was required to send her draft decision for review, And then the Legal Services Department unilaterally sent the draft to the executive chair without consulting the adjudicator. The adjudicator did not ask for help. The help was instead imposed upon her. The third issue the court had with this system was that the executive chair was in a position of authority over the adjudicator. So, I mean, think about this. If your boss suggests you change your decision, what choice do you really have here? You know, the court said that, well, there's nothing wrong with a tribunal implementing a review process. There is a perception of bias when the process is imposed on the adjudicator by an authority figure with no safeguards for the adjudicator's independence. Ultimately, what happened here is the divisional court set aside the decision and referred the matter back to the LAT for a new hearing. The LAT and Peel Mutual Insurance Company appealed the divisional court's decision to the Court of Appeal. That appeal was heard in April of 2019, and the Court of Appeal's decision was released last fall. Ultimately, though, what the Court of Appeal found is precisely what the divisional court found. There was a reasonable apprehension of a lack of independence, and the Court of Appeal ordered a new hearing to take place. Now, in preparing for a presentation that I gave back in the fall of 2018, I wrote to the LAT and I asked, in light of the divisional court's decision in Shuttleworth, what safeguards, if any, the LAT had put in place to protect an adjudicator's independence. This is the response that I received from the LAT with respect to my question. Now, keep in mind that this response came after the divisional court's decision was released, but before the Court of Appeal decision was released. And this is basically, I cut and pasted it from the email I received from the LAT. It is LAT's position that members' participation in the peer and legal review process is a resource for adjudicators. It provides a key element of adjudicator training and development and ensures consistent, quality decision-making. Further, this process assists in avoiding unnecessary reconsiderations, reviews, judicial reviews, and appeals, thus minimizing complexity and cost to the parties. Ultimately, the review process ensures quality service to the public. Now, this very well may be so, but the difficulty that the divisional court had and the difficulty that the Court of Appeal ultimately had is there were no safeguards in place to protect judicial independence. And the LAT really didn't answer that question. What safeguards, if any, have they put in place? The LAT went on to say, I can confirm that the Court of Appeal granted leave to appeal with the consent of all parties in the matter of Shuttleworth. The matter will be heard at a date yet to be determined. As the matter is before the courts, it would be inappropriate to comment further. You know, it's really scary on the part of an individual to know that they could be going for a hearing. They're spending legal fees in order to do that, and they're not ensured that there is judicial independence on the part of the adjudicator who hears all of the evidence. As I said, the Court of Appeal did agree with the divisional court. I've given you excerpts from the decision, which in essence shows the basis for their decision. They did, in fact, find there was a reasonable apprehension of a lack of independence on the facts of the Shuttleworth case. And they reached that conclusion for very similar reasons to the divisional court. And I will leave it to all of you to read these excerpts. The third issue with the LAT, the question I posed was, had it improved the dispute resolution system? And the answer I gave was that no, it hadn't. And the next reason for why I would say it hadn't is because we are now dealing with a no-cost system. The LAT has made it clear through its rulings to date that there is no meaningful ability to recover costs, even if a party is successful at a hearing. The right to a cost award at the LAT is found in Rule 19.1. And what that rule says is where a party believes that another party in a proceeding has acted unreasonably, frivolously, vexatiously, or in bad faith, that party may make a request to the tribunal for costs. So it's clear from Rule 19.1 of the Common Rules that the LAT does in fact have jurisdiction to award costs. What the LAT has unfortunately done, though, is interpreted this section to mean that the bad behavior, so the unreasonable, frivolous, vexatious, or bad faith behavior, must have occurred during the course of the proceeding. For example, or specifically, after the application to dispute has been filed. So any bad behavior that occurred before the application to dispute is filed doesn't count. So it doesn't matter if the insured doesn't respond to requests for benefits or denies requests for benefits without a basis for doing same, or doesn't comply with the statutory accident benefits schedule. So long as they play nice, once the application for arbitration is filed, there is no right to cost. In a LAT decision, adjudicator Trexler indicated specifically, and I'll quote, the actions and or behavior of a party that occurred prior to the filing of an application to the tribunal cannot be considered in making a cost award. And this, quite frankly, is just absurd. It really, really does not make it easy to resolve these cases and or to resolve the issues prior to bringing them to a hearing. It in essence means that the insurer can deny benefits and force the insured person to incur costs at the LAT. And again, so long as they play nice during the course of the LAT proceeding, the insured has no entitlement to costs. It also means there are no consequences whatsoever if a party takes an unreasonable position. There are only a handful to date of LAT decisions where costs have been awarded. When I looked at the numbers about a year ago, there were only 6 decisions, and I believe there's very few that have been released since then. And that's in comparison to the hundreds and hundreds of LAT decisions that have been released over the last few years. These cost awards relate to a party's legal fees, what they will need to pay a lawyer to represent them. They also relate to disbursements, being the out-of-pocket expenses each side needs to incur to fund the claim, such as expert reports, medical reports, and so on. When you look at the cost awards that have been made to date, they range from $250 to $700. That's not a lot of money. Certainly most lawyers will charge more on an hourly basis than some of these cost awards that have been made. But that's it. This is all that has been awarded. So if someone fails to show up at a case conference, for example, you might get $250 if you're lucky. But 9 times out of 10, there will be no cost award at all. The LAT jurisprudence makes 2 things very clear. First and foremost is that there is no entitlement to the actual costs incurred. So you can see my cartoon in the bottom of the slide, free lawyer, no free lawyer, free lawyer. Well, in essence, the LAT must think that lawyers work for free because the actual cost that a party has to incur to fight a LAT dispute will never be recovered. Adjudicator Bickley held in a case involving Aviva that satisfying the Rule 19 requirement to cost does not entitle a party to an award on a full, partial, or substantial indemnity scale. Similarly, in a case involving Unifund, adjudicator Trong held that an award of costs is not meant to be an assessment of the actual costs a party has had to incur as a result of the claim. The second thing that the LAT jurisprudence has made clear is that there is no entitlement to the payment of disbursements. And again, disbursements are all of the out-of-pocket expenses that parties need to incur. So, paying the experts to prepare a report or to attend at the hearing, paying the summons to witness fee to summons all of your witnesses, paying for documents that you require for the purposes of the hearing. None of this is recoverable at the LAT. Rule 19 is silent on this issue. It says nothing whatsoever about disbursements. And, certainly in the past when we were dealing with FSCO, we would not only be able to recover our legal fees, but we would also be able to recover our disbursements. So the hope was that the LAT would at least follow suit in the case of disbursements. If you take, for example, a catastrophic determination issue, it will often cost a party at least $16,000 to $20,000 just to do assessments to determine whether or not the person is catastrophic. I had one last fall, and I think we spent over $40,000 to our experts alone, just on their expert reports and then their review of the insurance company's reports. These disbursements can rack up pretty quickly. It's unfortunate, though, because the LAT has made clear that there is no recovery for the cost of disbursements. Adjudicator Gottfried put this argument to bed in a recent 2018 decision wherein the adjudicator held that the tribunal does not issue rulings for the payment of expenses that are in the nature of disbursements. The LAT has, as a result, become a truly no-cost system. It really heightens the David and Goliath situation that most people find themselves in. The insurance companies have the funds and the resources to hire a lawyer and litigate these disputes. Most insured people obviously do not. And so when they would hire the lawyer would assess, the likely chances of success and take the case on the understanding that they would get paid if they're successful. Well, now there's no recovery if you're successful. And so the only way that a lawyer can get paid is by taking some of the benefits that are being fought over. So it really puts an insured person in a very, very difficult situation. And quite frankly, becomes an access to justice issue. If they can't find a lawyer to take on their case, what chance of success do they have against the Goliath insurance company? Now, there is one ray of hope here. There is the Carr and Modi decision. It's a 2016 divisional court decision. It emanates from a tort claim where the parties were trying, or the plaintiff was trying to recover the SABS costs. So in the SABS claim, the plaintiff would have disputed denials of benefits and recovered benefits through arbitration in the SABS context, and was then taking the costs that should have been recoverable there and trying to instead recover them from the tortfeasor. And what the judge said is there is considerable authority supporting the determination of the motion judge that a plaintiff's recovery of SABs may constitute a benefit to the defendant in the tort claim. So remember, the tortfeasor gets credit for any SABs that are recovered. So if my client takes a claim to arbitration and is successful on catastrophic determination, I've then given the tortfeasor a $1 million credit. So the tortfeasor is certainly benefiting from any recovery I make of the SABs in my plaintiff's claim. And so the court went on to say, accordingly, a plaintiff may be entitled to claim the unrecovered costs incurred in arbitration to obtain the SABs. And so because of this, many plaintiff lawyers will then take the costs incurred in fighting a SABs claim and move them over to the tortfeasor and ask that they pay those costs. Now, this case, though, you should know, did involve a FSCO arbitration. There are currently no decisions that I am aware of dealing with tort insurers paying the cost of a LAT arbitration, but certainly the same argument would apply. The tort insurer reaps the benefits of the SABs the plaintiff obtains, and as a result, the plaintiff should not have to bear all of the risk and cost of pursuing these benefits. So, if we're stuck with no costs from the LAT, this case can hopefully give a mechanism to at least fund those SAB disputes where there is, in fact, a tort claim. Now, when the LAT first came out, there was a lot of uncertainty amongst the stakeholders. Certainly, the FSCO decisions were not binding on the LAT, and so there was a lot of uncertainty. Would they follow the law that had previously been set by FSCO? How would they conduct hearings? What really would take place. And so there has been some comfort in knowing that the LAT has largely followed the existing FSCO case law for the most part. The LAT has also opted to hear many of their cases in writing, which has saved the parties tremendous costs. The other thing to know is that most of the cases that have been heard by the LAT relate to issues pertaining to the minor injury guideline. And we talked a bit about the MIG before. It was really put in place to try to save the insurance company costs and keep premiums down. But what it has instead done is increase the legal disputes. So it really hasn't been much of a huge cost saver. So we've talked about disputes and what do the parties do if they can't settle the case. Let's also talk about what happens when they can settle the case. Because, while there are a lot of disputes that do go to hearing, there are a number that will settle. And the interesting thing about a SABs dispute is that similar to the rules and protocols with respect to a hearing, there are also rules and protocols with respect to settling a claim, and those rules and protocols must be followed as well. So the parties can't just simply come to an agreement and walk away from each other. There is a number of forms that do need to be completed, and there are circumstances in which the parties are not allowed to settle a claim. So these rules are found in section 9.1 of section E of the Dispute Resolution Practice Code. And you can see from subsection 1, settlement means an agreement between an insurer and an insured person that finally disposes of a claim or dispute. So that is really the key definition there. So these rules only apply if you are finally disposing of a claim or dispute. So if, for example, the insurance company terminates the income replacement benefits and then decides to reinstate them and continue paying. That is not a final settlement because the benefit is continuing to be paid ongoing. If, however, a lump sum agreement is reached such that the insurance company gives the individual, say, $50,000, and the individual then gives up their right to ever claim income replacement benefits again, that would constitute a final settlement, and these rules would then apply. Under subsection 2, the insurance company is required to provide the insured person with a written disclosure notice signed by the insurer with respect to the settlement. And this disclosure notice is very important because it outlines all of the insured person's rights. Because remember, the SABs are designed so that an individual does not need to require a lawyer. And so because of that, the Financial Services Commission wants to make sure that individuals who finally dispose of their claims are advised of all of the rights that are available to him or her before doing so. So this slide outlines what the settlement disclosure notice contains and basically what it says to the insured person. The settlement disclosure notice is a standard form document. All insurance companies are required to use the exact same document. So the first thing that it talks about is the insurer's offer, and it's required to set it out with respect to what it entails. And so when you look at the form, the very first page of the form lists all of the various benefits to which the individual may be entitled and has a monetary amount next to it depicting what the insurance company is offering to the individual. There is then a verbal description of each benefit that may have been available. And then there's a statement advising the individual of the 2-day cooling off period. So, you'll remember from contracts, once you have, your offer, your acceptance, and your consideration, it's a done deal. Well, here in the SABs, the legislation mandates a 2-day cooling off period, meaning that the individual insured person has 2 days to change his or her mind, and the agreement is not effective until that 2-day cooling off period has expired. So the settlement disclosure notice specifically outlines that right to the insured person so that he or she is made aware of it. The settlement disclosure notice also includes a description of the consequences of the settlement, including a statement of the restrictions contained in the settlement on the insured person's right to mediate, litigate, arbitrate, and so forth. Basically, that it is in fact a final settlement and that the individual cannot later apply for these benefits. It also has a statement that the tax implications may be different from the tax implications of the benefits described. Number 5, there is a statement advising that the insured person can obtain independent legal, financial, and medical advice before entering into the settlement, and the insurance company is obligated to give the individual an opportunity to do that should they wish to do so. And then there is a statement for signature by the insured person acknowledging that he or she has read the disclosure notice and considered his or her need to seek independent legal, financial, and medical advice before entering into the settlement. Now, before I move on from settlements, I just want to mention one more thing. There are restrictions on an individual's ability and insurance company's ability to settle a statutory accident benefit claim within the first year after the accident. So a claim cannot be finally settled within that first year unless the insured person referred the matter to arbitration and a pre-hearing conference was held So, subject to that, there would be no ability to resolve the claim. So, it's really only giving people an ability to resolve a claim within that first year if an arbitration did in fact take place, or at least had been filed for and the pre-hearing had happened. This is really to protect the insured person and make sure that they don't resolve a claim too early. Now, you will have heard me talk about the duty of good faith throughout the course. This is an obligation that is on all insurance companies. They owe this duty of good faith towards their insured persons. And basically, the duty requires them to assist their insured persons to act promptly and fairly when investigating, assessing, and attempting to resolve claims made by its insured. And any breach of this duty of good faith would apply if an adjuster has unreasonably denied a benefit to the insured. So you can see my little cartoon. I know we're supposed to be totally loyal, but to whom? Well, the insurance companies are supposed to be totally loyal to their insured persons. They are supposed to help them and make sure that they receive all of the benefits to which they are entitled. The statutory accident benefits has been deemed by the Supreme Court of Canada to be consumer protection legislation. The insurance companies, as I said, hold the purse strings. They are in a significant position of power over the insured persons, and they must exercise that power responsibly. So, think of the income replacement benefit situation. An individual is out of work and has no real understanding of what benefits are available. The insurance company has an obligation to advise that individual of the benefits that are available and help that individual fill out the forms and assess that individual's claim fairly and in an unbiased manner. This goes even further. The insurance company cannot deny a payment without just cause. It is imperative that the insurance company ensure that they comply with the statutory accident benefit and treat the insured person reasonably and fairly. Now, there are mechanisms in place to protect an insured person from an insurer who abuses their power. Because quite frankly, at the end of the day, insurance companies are in this to make a profit. They also have a number of adjusters who often have too many files for the time that they have to adjust them, or who perhaps are not trained properly or are inexperienced or misunderstand this obligation that they have. And so there are a number of cases where you will see insurance companies abusing this duty of good faith. Special awards are the primary way that insured persons can hold insurance companies accountable. Special awards are very similar to punitive damages that are available through the civil courts. It's legislated, the special awards are legislated under Section 10 of the Insurance Act regulation dealing with the License Appeal Tribunal. Arbitrators are entitled to award them, and here's how they are calculated. So these special awards are only available if the tribunal finds that an insurer has unreasonably withheld or delayed a benefit. Now, it's important to know, and I've written this at the bottom of the screen, there need not be any ill will, intent to harm, or intentional conduct on the part of the insurer. All that is required is a finding by the tribunal that the insurer unreasonably withheld or delayed the payment. So they didn't need to intend to unreasonably withhold it, or they didn't need to be mean-spirited. So long as they unreasonably withheld it, the individual is in fact entitled to that payment. Now, you can also see from the schedule or from the section of the regulation that the tribunal may award a lump sum of up to 50% of the amount to which the person was entitled at the time of the award, together with interest on all amounts owing to the insured. So, think about the situation if we're dealing with, $5,000 in physiotherapy treatments. The special award is limited to $2,500, 50% of that $5,000. So in many cases, these awards are not really enough to fully punish the insurance company, which is a multi-billion-dollar industry. But if you were dealing with, for example, a catastrophic case where there's hundreds of thousands of dollars outstanding, then it could potentially be a sizable award. So it really depends on the amount of money that's an issue as to how effective these awards would be. And so again, you can see how they're calculated. The arbitrator will order that the insurer make the payment plus interest, and in addition to that payment, they will order that lump sum of up to 50%. In the case of Persofsky and Liberty Mutual, this is a Financial Services Commission decision. And in this case, Director Draper outlined a number of factors to take into consideration when determining the amount of a special award. Because while the adjudicator has the ability to order up to 50%, the adjudicator does not automatically award 50%. And so the factors that will be taken into consideration are number one, the amount of the benefits unreasonably withheld or delayed, the time the benefit has been withheld or delayed for. So if we're talking about 2 years versus 3 months, the 2 years may result in a higher award. Failing to respect important obligations under the SAVs. So, if they ignore the rules, there may be a higher award in those situations. And then other factors that increase the gravity of the insurer's conduct, mitigating factors, other penalties, and interest. The adjudicator also went on to say that arbitrators are to consider all relevant factors to determine an appropriate lump sum special award. It should not be a percentage. Even though they have that entitlement to award up to 50%, the award should be phrased as a lump sum, so $2,500 versus 50%. And the lump sum should respond to the facts of the particular case, bear a reasonable relationship to other special awards made, and it should not exceed the maximum of 50%. When a special award is made, arbitrators are also to provide reasons for the award, and again, express the special award as a lump sum, not as a percentage. And no interest is payable on the amount of the award except as part of the enforcement process. So that is basically it for this class. We've gone through the dispute resolution process. It is certainly not an ideal process. You can see from special awards when dealing with multi-billion-dollar insurance companies that we do not always have a lot of teeth to these punishments, but it is still available. And there is a case from about a year and a half ago dealing with a catastrophic dispute and a number of benefits where the benefit awards coupled with the special award, I believe, exceeded $700,000. So there are some cases like that, but again, the vast majority of these cases will really result in very small special awards. So I hope this lecture was helpful, and if any of you do have any questions, again, please do not hesitate to email me. I will certainly make myself available and am happy to talk through any of the issues raised in the lecture. So thank you very much.